Hi, welcome back everyone. Today we are going to discuss about authorities under the Act, that is Industrial Dispute Act 1947. The various authorities constituted under the Industrial Dispute Act 1947 for the settlement of industrial disputes are: first one, Works Committee; second, Conciliation Officers; third, Board of Conciliation; fourth, Court of Inquiry; 5, Labor Court; 6, Industrial Tribunal; 7, National Tribunal; 8, Arbitrators; 9, Grievance Settlement Authority. Works Committee. Under Section 3 of Industrial Dispute Act, the appropriate government may by general or special order require the employer to constitute in the prescribed manner a Works Committee in the case of any industrial establishment in which 100 or more workmen are employed or had been employed in any day in the preceding 12 months. Constitution of Works Committee. A Works Committee consists of the representative of the employers and workmen engaged in the establishment. The number of representatives of workmen shall not be less than representatives of the employer. The representatives of the workmen shall be chosen in the prescribed manner from among the workmen engaged in the establishment and in the consultation with the registered trade union, if any. Its duties. That is the duties of Works Committee. The following are the duties of the Works Committee. A. To promote measures of securing and preserving amity and good relations between the employers and workmen. B. To achieve the above object, it is their duty to comment upon matters of common interest or concern of employers and workmen. C. To endeavor to settle any material difference of opinion in such matters. It was held in Kemp & Co. Limited versus their workmen in 1955 that the decision of Works Committee have great weight although they are not conclusive. Northbrook Jute Company Limited versus their workman. Northbrook Jute Company Limited versus their workman. It was contended before the Supreme Court that the Works Committee, which was duly constituted under the Act, had approved the scheme of rationalization after due consideration. It was further pleaded that, as the representative of workmen on the Works Committee had accepted the scheme, the workman should be deemed to have agreed to it. The Supreme Court observed that the representatives of the workmen on the Works Committee do not represent the workman for all purposes but only for the purposes of the functions of the Works Committee. The Works Committee was not intended to supplement or supersede the unions for the purpose of collective bargaining. Their task is only to smooth away frictions that might arise between the workman and the management in day-to-day work. Conciliation Officer. After Works Committee, we are going to discuss about Conciliation Officer. The appropriate government may, by notification in the official gazette, appoint such number of persons as it thinks fit to be conciliation officers charged with the duty of mediating in and promoting the settlement of industrial disputes. This is discussed in Section 4 of Industrial Dispute Act 1947. A conciliation officer may be appointed for a specified area or for one or more specified industries and either permanently or for a limited period. Section 11 of Industrial Dispute Act speaks of the conciliation officers. A conciliation officer may, for the purpose of inquiry, enter into any existing or apprehended industrial dispute after giving reasonable notice, enter the premise occupied by any establishment to which the dispute relates. That is discussed in Section 11 of Industrial Dispute Act. A conciliation officer may call for and inspect any document which he has ground for considering to be relevant to the industrial dispute or to be necessary for the purpose of verifying the implementation of any award or carrying out any other duty imposed on him under this Act, and for the aforesaid purpose the conciliation officer shall have the same powers as are vested in a civil court under the Code of Civil Procedure 1908 in respect of compelling the production of documents. A conciliation officer shall be deemed to be a public servant within the meaning of Section 21 of Indian Penal Code, and that with respect to Industrial Dispute Act is given in Section 11 subclause 6. So, a conciliation officer shall be deemed to be a public servant within the meaning of Section 21 of Indian Penal Code. This provision is given under Section 11 subclause 6 of Industrial Dispute Act. Now, the duties of a conciliation officer. 1. Where any industrial dispute exists or is apprehended, the conciliation officer may, or where the dispute relates to a public utility service and a notice under Section 22 has been given, shall hold conciliation proceeding in the prescribed manner, that is Section 12 subclause 1. So, the first duty, there are two instances, that is where any industrial dispute exists or is apprehended. Here, the conciliation officer may, that is, the conciliation officer can use the discretion where the dispute relates to a public utility service, and the second instance is that when a notice under Section 22 has been given, the conciliation officer shall, so that is a mandatory, shall hold conciliation proceeding in the prescribed manner, that is Section 12 subclause 1. So once again, Section 12 subclause 1, with respect to holding of conciliation proceeding by conciliation officer, two instances are there. One, where the conciliation officer can exercise a discretion, that is when there is an industrial dispute existing or is apprehended and the industry is a public service industry. And the second scenario is where a notice under Section 22 has been served. In these, where a notice is served, the conciliation officer must or shall hold the proceeding, and in when it is with respect to a public service utility and there is an apprehension or a dispute existing, then the conciliation officer may, by his discretion, hold conciliation proceeding. This is discussed in Section 12 subclause 1 and the first duty of conciliation officer. The second duty. The conciliation officer shall, for the purpose of bringing about a settlement of the dispute without delay, investigate the dispute and all matters affecting the merits and the right settlement thereof, and may do all such things as he thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement of the dispute, and that is discussed in Section 12 subclause 2. The third duty. If a settlement of the dispute or any of the matter in the dispute is arrived at in the course of conciliation proceeding, the conciliation officer shall send a report thereof to the appropriate government or an officer authorized in this behalf by appropriate government, together with the memorandum of the settlement signed by the parties to the dispute. That is discussed in Section 12 subclause 3. Now, the fourth duty. If no such settlement is arrived at, the conciliation officer shall, as soon as practicable, after the close of investigation, send to the appropriate government a full report stating the steps taken by him for ascertaining the facts and circumstances relating to the dispute and for bringing about a settlement thereof, together with a full statement of such facts and circumstances and the reasons on account of which, in his opinion, a settlement could not be arrived at. And this is discussed in Section 12 subclause 4. If the fifth duty, if on consideration of the report referred to in subsection 4, that is 12 subclause 4, the appropriate government is satisfied that there is a case of reference to a board, labor court, tribunal or national tribunal, it may make such reference. Where it does not do so, it shall record and communicate to the parties concerned its reasons thereof. That is discussed in Section 12 subclause 5. Now, the sixth duty, that is, a report under this section shall be submitted within 14 days of the commencement of the conciliation proceeding, or within such shorter period as may be fixed by the appropriate government, and that is discussed in Section 12 subclause 6. So, the duties of the conciliation officer are discussed under Section 12 subclause 1 to subclause 6. Now, further, provided that the subject to the approval of the conciliation officer. So that is there is a proviso to section 12, provided that subject to the approval of the conciliation officer at the time for submission of the report may be extended by such period as may be agreed upon writing by all the parties to the dispute. That is also under section 12. So the next one is settlement arrived in course of conciliation proceeding. So in ITC Limited Workers Welfare Association versus Management of ITC, ITC Limited Workers Welfare Association versus Management of ITC 2002. In this case, the Supreme Court declared that a settlement arrived in the course of conciliation proceeding carries a presumption that it is just and fair and that it is binding on all workmen. Court further ruled that when there is such a settlement, individual employee cannot seek to wriggle out of it mainly because it does not suit him. In the same case, the court also declared that the settlement arrived in the conciliation proceedings cannot be tested on the touchstone of Article 14 of the Constitution, especially when the employer corporation is not state or other authority. So once again, in the same case, that is ITC Limited Workers Welfare Association versus Management of ITC 2002, the Supreme Court also declared that the settlement arrived in conciliation proceedings cannot be tested on the touchstone of Article 14 of the Constitution, especially when the employer corporation is not state or other authority. While refusing to refer a dispute, the government must give reasons under section 12 subclause 5 that it may be judicially scrutinized. That was held in Vishnu Sahai versus Manager 1972. In Vishnu Sahai versus Manager 1972, the court held that the reason for denial of reference of a dispute by the appropriate government, as in section 12 subclause 5, that may be judicially scrutinized. Now, after Works Committee and Conciliation, the next authority is Board of Conciliation. We are going to discuss about Board of Conciliation. Under section 5, the appropriate government may, as occasion arises, by notification in the official gazette, constitute a Board of Conciliation for promoting the settlement of an industrial dispute. A board shall consist of a chairman and 2 or 4 other members as the appropriate government thinks fit. The chairman shall be an independent person and other members equally represent the parties to the dispute. Such representatives are appointed on the recommendation of the parties concerned. If any party fails to make a recommendation as aforesaid within the prescribed time, the appropriate government shall appoint such person as it thinks fit to represent that party. That is proviso to section 5 subclause 3. Now, a board having the prescribed quorum may act notwithstanding the absence of the chairman or any of its members or any vacancy in the number. But if the government notifies that the service of the chairman or any other member have ceased to be available, the board shall not act until a new chairman or member, as the case may be, has been appointed. And that is discussed in proviso of section 5 subclause 4. Now, duties of the board. 1. Where a dispute has been referred to a board under this act, it shall be the duty of the board to endeavour to bring about a settlement of the same. For this purpose, the board shall in such a manner as it thinks fit and without delay investigate the dispute and all matters affecting the merits and rights settlement thereof, and may do all such things as it thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement of the dispute. And that is discussed in section 13 subclause 1. Now, so the duties of the board is discussed under section 13. Now, 2. If a settlement of the dispute or of any of the matters therein is arrived at in the course of conciliation proceeding, The board shall send a report thereof to the appropriate government together with a memorandum of the settlement signed by the parties to the dispute. 3. If no such settlement is arrived at the board shall, as soon as practicable after the close of investigation, send to the appropriate government a full report setting forth the proceeding and the steps taken by the board for ascertaining the facts and circumstances relating to the dispute and for bringing about a settlement thereof, together with a full statement of such facts and circumstances, its findings thereon, the reasons on account of which in its opinion a settlement could not be arrived at, and its recommendation for determination of dispute. So a report containing all these factors, all these facts shall be sent to the appropriate government, and that is discussed in section 13 subclause 3. Now the fourth one, if on the receipt of a report under subsection 3 in the respect of a dispute relating to a public utility service, appropriate government does not make reference to a labor court, tribunal or national tribunal under section 10, it shall record and communicate to the parties concerned its reasons thereof. That is discussed in section 13 subclause 4. Now the fifth one, the board shall submit its report under this section within 2 months of the date on which the dispute was referred to it, or within such shorter period as may be fixed by the appropriate government, and that is discussed in section 13 subclause 5. Now we have two provisos, that is, provided that the appropriate government may from time to time extend the time for submission of the report by such further period not exceeding 2 months in the aggregate. And the second proviso, that is provided further that the time for submission of the report may be extended by such period as may be agreed on in writing by all the parties of the dispute. Now, towards the powers of the board, every member shall have all the powers exercised by the conciliation officers which have already been discussed. Apart from those powers, a conciliation board shall have the same powers as are vested in a civil court under CPC when trying a suit in respect of following matters, and 4 matters are discussed here. First one, enforcing the attendance of any person and examining him on oath. Second, compelling the production of documents and material objects. Third, issuing commissions for the examination of witnesses. Fourth, in respect of such other matters as may be prescribed, and every inquiry or investigation by it, that is the board, shall be deemed to be judicial proceeding within the meaning of section 193 and 228 of IPC. So, it is considered as a judicial proceeding within the meaning of section 198 and 228 of IPC. And this provision is given in section 11 subclause 3 of Industrial Disputes Act. So with respect to authorities, we discussed about Works Committee, Conciliation Officer, and now Board of Conciliation, and the next authority is Court of Inquiry, that is discussed under section 6, Court of Inquiry. The first one, that is section 6 subclause section 6, the Court of Inquiry. The first point is that the appropriate government may, as occasion arises, by notification in the official gazette, constitute a court of inquiry for inquiring into any matter appearing to be connected with or relevant to an industrial dispute, and that is discussed in section 10 subclause 1. And a court may consist of one independent person, or that is a court of inquiry. A court may consist of one independent person or of such number of independent persons as the appropriate government may think fit, and where a court consists of 2 or more members, one of them shall be appointed as the chairman, and that is discussed under section 6 subclause 2. Now, a court having the prescribed quorum may act notwithstanding the absence of the chairman or any of its members or any vacancy in the number, provided that if the appropriate government notifies the court that the service of the chairman have ceased to be available, the court shall not act until a new chairman has been appointed. A court shall inquire into the matters referred to it and submit report thereon to the appropriate government ordinarily within a period of 6 months from the commencement of its inquiry. A court of inquiry is vested with all the powers which are exercised by a board of conciliation. On perusal of the relevant sections relating to the court, especially section 22, 23 and 33 of Industrial Dispute Act, it may be seen that during the pendency of a proceeding before a court of inquiry, the following rights remain unaffected, and three rights are discussed. That is, the first one, the right of a workman to go on strike. The second, the right of an employer to lock out his business. The third, the right of an employer to dismiss or otherwise punish the workman in certain cases under section 33. So, with respect to the sections 22, 23 and 33 of Industrial Dispute Act, the right of the parties to the proceeding are unaffected in the following circumstances. That is, the first one, the right of a workman to go on a strike. The second, the right of an employer to lock out his business. The third one, the right of an employer to dismiss or otherwise to punish the workman in certain cases under section 33. So, with respect to authorities, we discussed Works Committee, Conciliation Officer, Board of Conciliation, Court of Inquiry, and the next one is Labour Court, which is discussed under section 7. So, section 7 of Industrial Dispute Act lays down the composition of the Labour Court. It provides as under: 1. The appropriate government may, by notification in the official gazette, constitute one or more labour courts for the adjudication of industrial dispute relating to the matter specified in the second schedule and for performing such other functions as may be assigned to them under the Act. 2. A labour court shall consist of one person only to be appointed by the appropriate government. Now, the matters provided in the second schedule are: the first one, adjudication on industrial dispute relating to any matter specified in the second schedule. Second, performing of such other function as may be assigned to them under the Act. The following matters are specified in the second schedule. The first one, the propriety or legality of any order passed by any employer under the standing orders. Second, the application and interpretation of standing orders. Third, discharge or dismissal of workmen, including reinstatement of or grant of or relief to workmen wrongfully dismissed. Fourth, withdrawal of any customary concession or privilege. 5. Illegality or otherwise of a strike or lockout. 6. All matters other than those specified in the third schedule. Now, qualifications for appointment. The qualifications of a person who can be appointed as presiding officer of the Labour Court are: A. He is or has been a judge of High Court, or B. He has, for a period of not less than 3 years, been a district judge or an additional district judge, or C. He has held any judicial office in India for not less than 7 years, or D. He has been presiding officer of a labour court constituted under the Provincial Act or State Act for not less than 5 years, and that is discussed in section 7 subclause 3. Or E. He has been presiding officer of a labour court for not less than 4 years. Or F. He has been a Deputy Chief Labour Commissioner, Central, or Joint Commissioner of State Labour Department, having a degree in law and at least 7 years experience in the Labour Department industry, 3 years of experience as a conciliation officer. Before such appointment, he should resign from the central government or state government. Or G. He is an officer of Indian Legal Service in grade 3 with 3-year experience in that grade. So these are the 7 options or qualifications. Either one should be satisfied. 7 instances are given. Either one should be satisfied for the qualification for appointment. Now, we have a case law here. That is the Statesman Private Limited versus HR Deb, 1968. The Statesman Private Limited versus HR Deb, 1968. In this case, the question was whether the magistrate holds a judicial office. The fact that duties of a magistrate are partly judicial and partly other does not detract from the position that while acting as a magistrate, he is a judicial officer. The phrase entitling a judicial office postulates that there is an office and the office is primarily judicial. But in Haryana Cooperative Transport Limited versus State of Punjab, 1969, Haryana Cooperative Transport Limited versus State of Punjab, 1969, registered to Pension Appeal Tribunal was appointed as presiding officer of a labour court. It was held that the appointment was void ab initio because the office of the registrar is administrative and not judicial in nature. Now, duties of labour court. Where the industrial disputes have been refined to a labour court or referred to a labour court for adjudication, it shall hold its proceeding expeditiously and shall, as soon as it is practicable, on the conclusion thereof, submit its award to the appropriate government. So it is the award and not a decree. Power of the labour court. A labour court shall enjoy the same power as enjoyed by a court of inquiry. In addition to those power, a labour court has full power to determine the question of cost of any proceeding before it. It shall also be deemed to be a civil court for the purpose of section 345 subclause 1, 346 and 348 of CRPC 1973. Now, it can also direct to reinstate a workman discharged or dismissed without justification on such terms and conditions as it thinks fit, and that is discussed in section 11A. Now, application of res judicata in labour cases, that is discussed in section 101B. That is res judicata in labour cases, section 101 capital B. In a decided case, that is AI 2003 SC 4701. In this case, the Supreme Court held that when the High Court has passed in a writ petition a recent order on merits and after contested hearing in a dispute relating to an initiation of service of a temporary workman, that becomes the matter and the issue cannot be re-agitated before a labour court. The court ruled that in such case re-agitation is barred by res judicata. So res judicata in labour cases is discussed in section 101 capital B. Now, the next authority, that is industrial tribunal. So we discussed worksman committee, conciliation officer, board of conciliation, court of inquiry, and then labour court, and next is industrial tribunal. The appropriate government may, by notification in the official gazette, constitute one or more industrial tribunal for the adjudication of industrial disputes relating to any matter, whether specified in the second or third schedule, and this is discussed in section 7 capital A. A tribunal shall consist of one person only to be appointed by the appropriate government. That is also discussed in section 7 capital A. Any person having one of the following qualification may be appointed as the presiding officer of an industrial tribunal, namely A. If he is or has been a judge of High Court or B, if he has for a period of not less than 3 years been a district judge or an additional district judge. It is provided by section 7 capital A subclause 4 that the appropriate government, if it thinks fit, may appoint 2 persons as assessors to advise the tribunal in proceedings before it. Now, duties and powers of Industrial Tribunal. The duties and power of the Industrial Tribunal are same as that of the Labour Court. And with respect to jurisdiction, the question whether an objection to jurisdiction of tribunal could be raised before the tribunal itself, or it is necessary to apply to the High Court to quash the proceeding before the tribunal, has been considered on a number of occasions by the court. There can be no difficulty where the question of jurisdiction is clear from the admitted facts. The difficulty of jurisdiction actually arises where the question of jurisdiction is mixed question of fact and law. In such cases, question should be raised before the tribunal itself, which shall determine the question after going into the facts. Once again, in such cases, when there is a mixed question of law and fact, the question should be raised before the tribunal itself, which shall determine the question after going into the facts. The proceeding before the tribunal comes to an end if it finds that it has no jurisdiction. If in its opinion the tribunal thinks that it has jurisdiction, it may proceed on to decide the industrial dispute itself. Where a preliminary finding is given by the tribunal, or the question of jurisdiction along with the dispute is decided by the tribunal, the High Court in appropriate proceedings may decide whether the tribunal has acted with or without jurisdiction. Ordinarily, the finding of fact with regard to the jurisdiction will not be interfered by with the High Court or Supreme Court. So, in general cases, the finding of fact with regard to jurisdiction will not be interfered with by the Supreme Court or the High Court. The finding of the tribunal may be set aside by these courts if it is found that the tribunal, while interpreting the facts, has misapplied any principle of law. While the objection as regards the jurisdiction was not raised before the tribunal, it cannot be for the first time raised before the court unless it is a pure question of law. So once again, when the objection as regards to the jurisdiction was not raised before the tribunal, it cannot be for the first time raised before the court unless it is a pure question of law. And we have a case law, that is in Pottery Mazdoor Panchayat versus the Perfect Company Limited, 1979. Pottery Mazdoor Panchayat versus the Perfect Company Limited, 1979. The Supreme Court held that the reference being limited to narrow question as to whether the closure was proper and justified, the tribunal may, by the very terms of the reference, had no jurisdiction to go behind the fact of closure and inquire into the questions whether the business was in fact closed down by the management. In this case, two questions were referred to the Industrial Court. The first one, whether the proposed closure by the management is proper and justified, and the second, to what retrenchment compensation are the employees entitled if it is decided that the proposed closure is not proper and justified. So the next authority is the National Tribunal, and that is the last of the authorities we are going to discuss here. We also have Grievance Settlement Authority. So we have discussed Works Committee, Conciliation Officer, Board of Conciliation, then the Court of Inquiry, the Labour Court, Industrial Tribunal, and now the next one is National Tribunal. The central government may, by notification in the official gazette, constitute one or more national industrial tribunals for the adjudication of industrial disputes, which, in the opinion of the central government, involves question of national importance or are of such nature that the industrial establishments situated in more than one state are likely to be interested in or affected by such disputes. A national tribunal shall consist of one person only to be appointed by the central government, who is or has been a judge of a high court. Now that is discussed in section 7 capital B subclause 2 and 7 capital B subclause 3. Now, duties and powers of National Tribunal. The duties and powers of National Tribunal are exactly the same as those of the Industrial Tribunal. Industrial Tribunal, deciding upon wage scale of the employees of an establishment, would have full liberty to grant proper ad hoc increase of salary as part of the revision of wages. Recently, Supreme Court held that where the reference being limited to a narrow question as to whether the closure was proper and justified, the tribunal by the very terms of reference had no jurisdiction to go behind the fact of closure and inquire into the question whether the business was in fact closed down by the management. And we already discussed this case, that is Pottery Mazdoor Panchayat versus the Perfect Company Limited 1979. Pottery Mazdoor Panchayat versus the Perfect Company Limited 1979. Now, disqualifications. No person shall be appointed to or continue in the office of Labour Court, Tribunal or National Tribunal if A. He is not an independent person, or B. He has attained the age of 65 years. Now, this is discussed in section 7 capital C. So, the disqualification that is applicable to the members appointed to Labour Court, Tribunal as well as National Tribunal. There are two instances. The first one, if the person is not an independent person, and the second instance is that the person has attained the age of 65 years. If for any reasons a vacancy other than a temporary absence occur in the office of the presiding officer of a Labour Court, Tribunal, National Tribunal, or in the office of the chairman or any other member of the board or the court, then in the case of a national tribunal, the central government, and in other cases the appropriate government, shall appoint another person in accordance with the provisions of the Industrial Dispute Act to fill the vacancy, and the proceeding may be continued before the Labour Court, Tribunal, National Tribunal, Board or Court as the case may be from the stage at which the vacancy is filled, and that is discussed in section 8. Only a vacancy other than a temporary absence shall be filled in the accordance with the provisions of Industrial Dispute Act. It means that the temporary absence shall not be considered a vacancy for the purpose of this section. Therefore, a vacancy shall mainly arise due to transfer or resignation or acquisition of any disqualification as provided under section 7 capital C of the Industrial Dispute Act. Now, finality of orders constituting boards, that is discussed in section 9. So, section 9 subclause 1 of Industrial Dispute Act provides that no order of the appropriate government or of the central government appointing any person as the chairman or any other member of a board or court or as a presiding officer of a Labour Court, Tribunal or National Tribunal shall be called in question in any manner on the ground merely of the existence of any vacancy in or defect in the constitution of such board or court. Now, the second, that is section 9 subclause 2. No settlement arrived at in the course of conciliation proceeding shall be invalid by reason only of the fact that such settlement was arrived at after the expiry of the period referred in subsection 6 of section 12 or subsection 5 of section 13, as the case may be. Now, the third one, where the report of any settlement arrived at in the course of conciliation proceeding before a board is signed by the chairman and all other members of the board, no such settlement shall be invalid by reason only of the casual or unforeseen absence of any of the members, including the chairman of the board, during any stage of the proceeding. that is Section 9, Subclause 3. The main object of enacting Section 9 of the Industrial Dispute Act is to make immune any order of appointment made under Section 5, 6, or 7 of the Industrial Dispute Act from being called in question. Therefore, no question can be raised whether an appointment was legally and properly made or not. It further protects any settlement from being invalid simply on the ground of the continuance of the conciliation proceedings beyond prescribed period. The provisions of Section 9 of the Act do not in any way cure the defect of want of jurisdiction. Once again, the provisions of Section 9 of the Industrial Disputes Act do not in any way cure the defect of want of jurisdiction. And it was held in Jagannath Vijaya Kale versus N.I. Ahmadi. Jagannath Vijay Kale versus N.I. Ahmadi, 1959. In this case, it was reiterated that the provisions of Section 9 cannot be used to cure the defect of want of jurisdiction. And here it was held, where the tribunal has not been duly constituted under the Act and it was acting without jurisdiction, the defect of jurisdiction would not in any way be cured by Section 9 of the Act. Further, in state of Haryana versus Haryana Cooperative Transport, a petition was moved to set aside the award of a labour court on the ground that its presiding officer was not qualified to hold the post of a judge under Section 7, Subclause 3, Subclause D of Industrial Dispute Act 1947. It was held that the word "in any manner" which occur in Section 9, Subclause 1 must be given a limited meaning so as to bar jurisdiction of civil courts in the ordinary exercise of their power to entertain a challenge to appointment mentioned in the subsection. The rights conferred by Article 226 and 227 can be abridged only by appropriate amendment of the Constitution, and their operation cannot be whittled down by a provision like the one contained in the Section 1 of the Act. Therefore, the High Court, in exercise of this writ jurisdiction, has power to consider the validity of appointment of any person as a chairman or a member of board or court, or as the presiding officer of a labour court, tribunal or national tribunal. So that was discussed in state of Haryana versus Haryana Corporation Transport. Now, the last authority we are going to discuss here is Grievance Settlement Authority. The newly added section 9, Subclause C, provides that the employer, in relation to every industrial establishment in which 50 or more workmen are employed or have been employed on any day in the preceding 12 months, shall provide for, in accordance with the rules made in that behalf under this Act, a Grievance Settlement Authority. So that is Section 9, capital C, Subclause 1. Section 9, capital C speaks about Grievance Settlement Authority. Now, powers and duties. The authority is meant for reducing the litigation outside establishment and for the expeditious and amicable settlement of individual disputes at employer and workman level. The authority shall follow such procedure and complete its proceeding within such period as may be prescribed. No reference shall be made to the board or court or arbitrator with respect to any individual dispute unless such dispute has been referred to the Grievance Settlement Authority concerned and the decision of the Grievance Settlement Authority is not acceptable to any of the parties to the dispute. So that is discussed in Section 9, capital C, Subclause 4. So Section 9, capital C deals with Grievance Settlement Authority. So with respect to authorities under Industrial Dispute Act, we discussed about Works Committee, Conciliation Officer, Board of Conciliation, then Court of Inquiry, in a tribunal, Industrial Tribunal, National Tribunal, Labor Court, and Grievance Settlement Authority. So that is the end of this session. Thank you for listening. Thank you for your support. Like, comment, and subscribe. Click that bell icon so that you get a notification once I upload my next podcast or a video. Thank you and have a nice day.